Well, hello, everybody. This is Dave Burkus, and I am a co-host of TCA Crossroads, along with my co-host, David Friedman. David,
How are you, Dave?
I'm doing great. This is a good day because, of course, we had technical issues, of course. And of course, it took us a while, and we have a guest sitting backstage that has probably fallen asleep by now. But all those things aside, let's have a good time today.
That sounds good. What's new in the world of investments for you?
Yeah, we had a $1 billion exit in DTX, and we had a $500 million exit in Influential Network, which
Oh,
I
nice.
helped to form way back when. So I feel really good about that one.
Well, congratulations. That's the old ACE fund?
Ace Fund 1, 2, and 3. So Ace Fund 2 is now doing great, paying carried interest, already 20% over the invested capital, and still doing fine. It's going to make a lot of money.
Yeah. I used part of the investment to buy my new computer and a new networking system for the house. Obviously, I need technical help to get it to work right, but that's a different issue. But it was a nice check to receive.
Not my job, but I'll just keep sending the money if you just keep building studios.
Well, I will do that. And who's our guest today?
Today it is Quan, and I'd like you to introduce him because you're the one that got him onto the show, and we have a great program today. If you saw the title for it, wasn't it to patent or not to patent? That is the
That is
question.
the question.
All right, let's do a little
All right.
Shakespeare together.
I'm missing Quan, though.
Is it time to wake up?
Yeah, he did wake up. Okay, he made the joke happen.
I actually did fall asleep. I was sort of just dozing off. It was meant to be a joke, that it happened for real.
That is funny,
Well,
and I'm
listen.
not going to edit that out. So you are now on stage.
Yeah, you're on stage. Quan Nguyen is a colleague of ours at TCA. Has been a long-term member of TCA, the Angel Group. He is fundamentally based in Orange County. Quan and his partners have a law firm that deals in patents. So who better to talk about to patent or not to patent? That is the question. And Quan, would you like to do any introduction or give a quick soliloquy of what we anticipate hearing?
How about your life story in 30 seconds?
I'm not a big fan of long introduction. My name is Quan Nguyen. I'm just so happy to be here with two of my most favorite people, David Friedman and David Burkus. Burkus, I've followed you through the years, watched your universities and stuff like that, signed up, so I've contributed to your fund. And actually some of our junior people, they're patent attorneys, but it's really important to understand the world of startups and business altogether. So I've made them as part of the training process to watch your videos as well. I've been practicing patents, now for a quarter of a century, I suppose. I love it. I can go on talking about it forever. So do shut me up when you've had an earful. So that's me.
Hey, we can do that. That's easy.
So
Okay,
I want to kick it off. I want to kick it off with a simple question that gets to the heart of it. We hear from entrepreneurs that they have a patent. Sometimes it's a utility patent. Sometimes it's a really strong technical patent. When do you patent versus when do you do a trade secret? And then we'll get into, are there specifics relative to different markets that you're playing in?
Of course. So before we talk about, do you patent or not to patent, or what are the options, keeping it a trade secret, and what are the other options? So let's just talk about patents first and what they are. So patents basically is a monopoly, and I can't think of any other legal monopoly that there is in the United States anymore other than patents. Effectively, you apply to the government that you have this thing, and you ask them for a monopoly on this thing, that nobody else can produce it for 20 years. And then in exchange for that, you would disclose how you do it, and disclose in its gory detail all the things that would allow another person, if they read it, they would be able to reproduce it and improve. So that's the whole exchange, is that the government asks you to make it such that people can read it, can improve on it only after 20 years. So that's the whole patenting deal. So now the thing about patenting is, like I said, if you're going to get a patent on something for a monopoly on your thing, then you have to divulge everything. And so, is it a good thing to divulge everything? Well, sometimes it doesn't matter, and sometimes it does matter. So it matters, and here's where it matters. First of all, when you file a patent application, it is going to be published after 18 months from the date that you apply for it. Well, actually, it's a little bit more technical than that. You apply for a provisional application if you want to start there, and provisional application is secret, nobody sees it. And at the 1 year mark, when the provisional application expires, you convert it or you file a non-provisional to continue that. Then 6 months after you formalize or continue with a non-provisional, it gets published. Now, if you file a provisional, you never do anything with it, well, then it just never gets published altogether, and no one sees it. No one can improve upon it and beat you to the punch. Okay, so when you file a patent application, it publishes within 18 months. Now, if you're working on a technology front where you're just a little tiny startup, and a competitor, if they see it after 18 months, they can bring in the force that be of a Microsoft, an Amazon, a Tesla, and they can just beat you to the punch with all the resources that you have. So what to do, right? So the other thing is to, well, not file it at all. Well, if you don't file it at all, you can keep it as a trade secret. But then again, it comes down to, well, if you're going to make a device, if it's an electronic device, if it's a physical device, if you're going to put it out there, what is there a trade secret anymore? Because people can see it, and even if you have it hidden in a box, they can crack it open. If it's a code, well, they can reverse engineer that as well. Yeah. So then the consideration comes down to a rock and a hard place. Okay, you put it out there, it might get hacked, not hacked, but someone can take it on and beat you to the punch. And you don't put it out there, well, and if you don't file, well, then when your product goes out there, they're going to get it anyway. So you have a little bit of a lead time on them, but then, you don't have anything to protect yourself. You don't get that monopoly anymore. So what to do? Well, first of all, you want to consider your area of technology. If something is very easily being reverse engineered or being capable of reverse engineering, well, then by golly, just file a patent application, because it's going to be reverse engineered anyway. So, at least if the big bad wolf is going to be out there lurking around, going to bite at you, and at least you have a patent to try to do something with it. And the subject matters that are very easy to reverse engineer is medical devices. It is what it is. You see it. There's no secret to it, right? Okay. Let's move over to the formulation a little bit. So if you have a formula, let's say you're going to have a formula, you're going to put some salt and some pepper and some things like that in there. If they're in their whole form, then, they can distill out the materials in there and see, and, move the grains out and see how many salt there is, how many grains of pepper there is. That's still very discoverable or engineer reversible. Okay. But now if you have a formula where these starting reagents begin to meld with each other, and it comes out in a different form to get to that final form. And if nobody knows what the original ingredients are, well, then okay, it could be a subject matter where you can have a secret sauce that nobody can get to. For example, Coca-Cola. It tastes good. You can do a spec on it and everything like that, but the way that in which they have their original ingredients, who knows what that is, right? That is a trade secret, because it's very difficult to reverse engineer. Same thing with Kentucky Fried Chicken. Kentucky Fried Chicken has a crispy, heart cholesterol clogging killer. People love it. I love it. But we don't know what ingredients they put together. And in fact, it is such a strong trade secret. They have it under lock and key. That story goes, legend is that there are several lockers for these things, and different people have different keys, and it takes the coming up together of many people to actually assemble this whole ingredient thing. That is a trade secret.
All right. Okay. So let's stop for a second and talk about the difference in patents in certain market spaces. Mm-hmm. Okay, because I want to have this interactive dialogue. Okay.
Sure.
And what's the difference if I have a medical device or a pharma product, or, to your point, a consumer product or a software product? Which one should be patented? Which one should be a trade secret? And let's break it into parts so we can ask questions on that, because we'd like to learn a little.
Anything physical you can readily see. So in this particular case here, a medical device, a pharmaceutics is, if you, the example I gave earlier is if you can dig into it, do some spec on it, you can see what it is, and by golly, just go ahead and file a patent application on that. Now, when you move over to more of algorithms and AI, for example, now that's where people have a lot of questions. These like, should I or should I not file a patent application on an artificial intelligence system or a system that produces certain things? So with that, the answer is it's somewhere in between. So you can file, well, first of all, AI basically is an algorithm in which you train it with data set and stuff like that. And there are many ways to get at filing an artificial intelligence related invention. So the big thing about artificial intelligence is a lot of times it's a black box. You set up your algorithm in which you then put your data in there, and it changes in form in which nobody even knows what it is. So there is room to keep that a trade secret, and the data set, for example, you can keep that a trade secret as well, because data set, it does impact what the final configuration of that wiring is within artificial intelligence. So with the things that are going to be difficult to have a visual of what it is, those things are excellent candidates for trade secret. Now, again, with a trade secret, though, just because you and I or a company calls it a trade secret doesn't make it so. We can't just self-anoint. It has to go through a rigorous process in which you have to have internal documentation within the company, employee handbook and stuff like that. So it's designated as trade secret, and there are certain protocols that you have to follow before it qualifies and becomes a trade secret. Saying so doesn't make it so. And importantly, and we encounter this quite a bit, is that someone would say, hey, you violated, you misappropriated my trade secret. The defense on it is, well, it was never a trade secret because you never kept it in a lock and key. And hey, you just walk into a room and there it is sitting on the computer, just turn it on, there it is. That is not a trade secret.
So Quan, let me tell you a story and you tell me a story, all right? That's how many people learn. So one of my companies had a blocking patent. 4 people had patents. All of them were about the same. Ours was the earliest. So we sued everybody. And Cisco came along, excuse me, the patent office to a clerk with 2,600 pages. And they dropped it on the clerk and tried to invalidate our patent. And so it cost us millions to get back into the game. And even then, we probably made 3 million and spent 2 million making it. So tell me your story. How do you know when a patent is something you really want to follow?
Sure. So let me get this cat out of the way, and I'll tell you the story. So I often have clients that come to us and say, hey, you know what? I'm going to make this thing, and it's a startup, by the way, and I'm going to sue everybody. Oh, goodness gracious. Excuse me.
Can I patent the cat?
Oh, yeah, the Schroeder's cat. Yeah. Let me just get this critter out of the way here. Come on. Up you go. There you are. Okay, bye. Okay, so they come. They come and they say, I'm going to sue, and so on and so forth. And I'm glad you brought up the numbers, because it takes millions to either defend or enforce a patent. And as a startup, the intention is not to have a patent to sue anybody, because heck, no investor want to invest into a company for a lawsuit. That's just not how it goes. So then what is the purpose of a patent? The purpose is to basically build up a portfolio that when you exit, there is something to sell, and the big boys would grab onto that and go sue. All right. So with your scenario where it costs so much money to defend yourselves, especially when they were trying to invalidate, well, I guess I don't know what else to say then, other than that's just bad luck, because when you have a patent, you hope to actually sell it to the big guys. And not to, and you didn't sue anybody, but in this case here, you had to defend yourselves from it, right? And so the hope is that there's I don't know, you tell me, if there was another big company that would come in to shoulder that cost to help out with defending that, and then hopefully with a collaboration of some sort that would come about. But that's a cost of doing business, and it's the Wild West out there where you go out. But at the very least, so your case scenario there, it was very painful. You spent $3 million to defend yourselves to make $2 million. So what is there at the end of the day for it though? That's a more of an exception than the rule. The rule usually is you build your patent application portfolio and then you sell it, and then you don't have to worry about what you had to worry about as a startup.
Yes.
So let me ask
Okay.
you a question relative to an investor now.
Mhm.
We look at deals and we have to judge whether or not having the patent makes sense. Are there certain markets where the patent is more important? For example, med tech, pharma, than in software, which is more trade secret, or in consumer? And the other question is, how do we determine? So the two parts, let's break them down.
Yeah.
When we invest, how do we look at the patent, and what market segments are more important than others to have that patent? The second one is, how do we determine the strength of the patent?
Yeah. So to begin with, it's always nice to have a patent or patent application that would turn to a patent than to not. Because when you have something, then at least you have the option to either continue going with a patent application and get a patent, or have an option of enforcing it or not, rather than have nothing at all. So that's a good place to begin with. And I suspect that's the reason why investors ask for patent status and filing and portfolio and strength, regardless of whether it is meaningful or not meaningful. So now let's go one layer deeper. Okay, one layer deeper is it even worth it? And it is, like you said, David, it is industry specific or industry dependent. So in the medical device space, it is important in that for the most part, when the Johnson & Johnsons of the world, Edward Life Sciences of the world, when they pick it up, they want to have something to buy and stop other major competitors of theirs as well. When you have a medical device company, usually you can't take it to IPO. Usually that doesn't. You can't take it to manufacturing. It's one of these things where you take it to a certain level and you sell. It's just the way it is, because it is so involved in FDA approval and sales force and stuff like that, in which it's very difficult for a startup to build all of that. So the exit strategy is usually to sell. And when you sell, well, there's got to be something to sell, and the IP is a big chunk of it. And so when the big company picks up on it, they want, so a Johnson & Johnson competes with Edward Life Sciences. They don't want to buy into a company with what? And then as soon as they buy it, Johnson & Johnson, Edward Life Science buys here, Johnson & Johnson just copies the exact same thing. Edward Life Sciences has the wherewithal, financial wherewithal to fight patent-wise to Johnson & Johnson, but they need something to fight with. Okay, so that's that part of it there. So then for the medical devices, yes. Pharma, absolutely. The challenge with pharma is that it takes a long time, a long road ahead in terms of just getting FDA approval and clinical and blah, 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 a lot of stuff in place. The key there, again, is very similar to medical device, where you're going to have to file, and then not only file, but keep up with the science. That's the one very unique thing of life sciences, or in this particular case, pharma, is that the research and the science changes, because at the very initial, you think that's what it is, but more so in the pharmaceutical, more so than other industry, it changes, and you realize how you can improve on it. So make sure that the filing has to keep up. And when you do that, you can accommodate for the patent lifespans as well, because it takes, let's say, 10 years to get from the initial idea to somewhere. The rule of thumb is $10 billion in 10 years. That's the rule of thumb for a drug to market, and it's probably changed a little bit more these days, longer or shorter, I don't know, but that's usually what it is. So you lose patent terms already, right? So then when you file these improvements, then you can push, okay, 20 years from here, 20 years from here, 20 years from here. So that builds it up, and it builds a nice portfolio for that. With where you don't file would be more of consumer products. It changes. It goes on the flimsiness of the of the liking of the consumer at the point. And also in the electronics world, technology changed so fast. By the time you get your patent, it's irrelevant. And I've seen this where it takes, when you file an application, it takes 2 years to hear back from the patent office. another year to actually get something. You're 3 years into it. And by the time 3 years into it, well, in the life science and medical devices, it's a slow moving thing. It's all good. But in the electronics world, in the high tech world, things are 3 years ago. It's just like, a century ago, relatively speaking. So in the electronics world, a little less so. But nonetheless, we do a fair number of electronics type work or electrical engineering type work or software work. If we go through at the very beginning to determine that this is the core, we have this conversation. Is this the core that anything improving on this would be just at the periphery, right? And if that is the case, then it's worth it. Otherwise, not worth it.
Which brings me to a subject that I have been advising people about for years, and I want to have your opinion on that. You build a patent thicket, which is a lot more money to do than a single patent, but because you're surrounded by other patents that you build, it's harder for somebody to penetrate.
Yes. And first of all, I love doing that because it's fun. And the reason is you get to ooze out all sorts of creativity and you build a patent portfolio, a patent thicket, as opposed to one. The analogy that I often give to our companies is this. When you go to battle, you don't want just a single arrow in your quiver. You want lots and lots and lots of arrows. Now, this has been played out in between companies umpteen times. You talk about Texas Instrument versus, oh my goodness, who the heck is it? These giants, when Google and Cisco, whomever it is, when they begin to launch rockets towards each other, one launches and the other launches 2, the other launches 5, and so on and so forth. Google is especially known for acquiring patents, not so much as they're going to do anything with it, not so much as they're going to produce products out of it. It's more so in leverage. In the event of any lawsuit against them, they have something to counterpunch with and to negotiate with. So then when you as a startup build that into your system and have a portfolio, they see, oh, wow, we're going to buy into another family portfolio that we can use and leverage for our purpose. IBM is known for that too, by the way.
So help us with cost. We have young companies in the main. How much does it ordinarily cost to file and to defend? Well, defend's hard to tell, but
an arm and a leg. so right. I am very realistic with our startups. Let's begin here. Not all patents create the same. Not all patent applications are created equally. You can get one for $2, and you get $2 worth of whatever it is. You can go to LegalZoom and do it yourself, and those are usually provisionals. And you can do these things yourselves. So it varies. Okay, it varies depending on the quality, depending on the firm, depending on the time that is put into it. Typically, I'll give you just typical standard number. This is a survey that's done by the National Organization of Intellectual Property, yada, yada, yada. Okay, so a provisional application, again, it's also dependent on technology area, mechanical engineering or electrical or pharmaceutical, average here. So average, when you start on a provisional application, anywhere from about $2,000 to $4,000. Once you file a provisional application, you have a 1-year runway in which by the end of that runway, you do a conversion to a non-provisional application. That ranges anywhere from 4 to 15. It's a big range, I know, but that's the range there. Sometimes more, but 4 is like the floor. Okay, 4 to 15. Usually it can end at about 10 or somewhere there. It's about 10. It's about the non-provisional. Now, once you file that, then you sit and you wait patiently, smile with a smile on your face. You wait for about 2 years and the patent office comes back to you and says, I reject everything. Well, okay, that's how it goes. 99% of the cases, I reject everything. All right, so now you're disheartened and you got to do something. So then you talk with your patent attorney and then you cobble and you basically look at the prior art that they cited and say, this makes no sense. And so then you arrange to communicate with the patent office. That process goes round by round by round. Usually it takes 2-3 rounds for you to get to a resolution, hopefully, that you get some allowance, which means that you pay the money and get your patent. Each round runs anywhere from $2,000 to $5,000. So you wait 2 years, you negotiate with them for about another year, 2-3 rounds, and so those are the dollars. Okay. Now, when you file your what I just described is very much a U.S. filing. In some industries, especially the pharma and the medical devices, they are more beneficial to the company when you file what's called international patent applications. Because when you look at a Johnson & Johnson or when you look at an AstraZeneca, they are not a US player only. They're everywhere. They're everywhere. If you look at, even Microsoft or some of the electronic companies, they're everywhere as well. So it's very industry dependent. Is also you look at who it is that is the potential buyer of your startup. And if they are a global player, then you want to deploy your patent applications internationally. How does one do that? One does that by, again, starting off with a provisional. At the 1 year mark, when you do your US conversion, you also file this thing is called a PCT application, Patent Cooperation Treaty. And the PCT application effectively is like an option, It gives you another 18 months to decide. At the end of 18 months, you then decide, okay, in addition to the US that I filed, I would like to go into China, Japan, Mexico, Australia, whatever. You pick as many countries as you like. Each one of those countries, as you seek application in them for filing, they range anywhere from 2,000 to 15,000. And this is why. Your 2,000-ish, you're looking at countries where there's no translation. Canada,
So we have just basically running out of time, but so the point on all this stuff is just to summarize, that I see is that you have to judge whether or not the patent is worth it relative to the market space. You have to judge who your potential competition is, and if there are large companies that will challenge you, you may not want to file the patent to make it very clear that this is something you have, because a trade secret may be worthwhile. Regardless, you need multiple patents in a patent family to protect the initial patent, and it's not exactly cheap, but it's worthwhile from an investor point of view to find companies that have strong patents, because you have the opportunity to be able to sell those patents for a lot of money. Dave, do you want to add and conclude?
There are so many more fine-tuned points about this, Quan. You have frustrated me, but I've been taking notes. And there are so many countries that we in my companies have filed patents in where you have to prepay to the court, and the loser pays everybody's fees. And it gets on and on. And so there are lots of other stories to tell.
Yeah.
Lots of other that I'm sure you can tell. I've only had a few experiences. So we might bring you on again sometime, because stories is how we all learn. And
Yes.
some more.
Yes. I'd love to hear those stories too. I live off of them.
Me too. Yes. So David and Quan, thank you very much. We're going to end this one for 28 golden minutes. We have learned a lot. Quan, thank you. And we may invite you back again to get more.
Can I go back to my nap now?
You can go back to your nap, because here comes the close.